Hello, everyone. Welcome to today's program, Modernizing Severability and Delegation Clauses in Employment Arbitration Agreements. Lessons from Sandler v. Modernizing Medicine, Inc. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Jared Slater. Jared is a partner in Ervin Cohen Jessup's Litigation and Employment Departments, where his practice focuses on defending labor and employment matters, including wage and hour, harassment, and discrimination claims in both individual and class action settings, as well as professional liability defense for clients facing malpractice claims. He's a frequent author on issues pertaining to labor and employment, arbitration, and ADR, with close to 100 published articles on these topics. We can't wait to hear what he has to share with us today, so I'm going to now turn it over to him.
Thank you, Allie. Hi, everyone. Really an honor to be here presenting for you. This is actually my first time, so please, at the end of the seminar, feel free to leave your feedback, not only for the bar, but for me. It'll help me improve on anything I can do next time. But I am here and delighted to be able to talk about Sandler versus Modernizing Medicine, Inc., a case that came down really about 3 months ago. And the question in that case is this: employers all the time put in arbitration agreements for their employees, and they put in certain clauses. They put in both a severance clause saying, if anything is wrong with our severance, if anything is wrong with our arbitration agreement, those unconscionable provisions could be severed. And then they put in, very commonly, a delegation clause. And the delegation clause says, well, we don't necessarily want the courts to decide if our agreement is enforceable or valid. Rather, we want somebody else, typically the arbitrator. And that's what Sandler versus Modernizing Medicine addressed, this perhaps some tension. And we will talk about that over the next hour today. The clicker is not working. Sorry.
All right, Jared, it looks like we actually are seeing the back end of your presenter view currently. If we could, I believe there's an ability to switch the monitor. Perfect.
Oh. All right. Thank you for the patience, a little technical glitch, but we're on our way. So what are we going to talk about today? We're going to start with the framework. We're going to start with the FAA. We're going to start with arbitration agreements and clauses in general, the Federal Arbitration Act delegation clauses, and the clear and unmistakable standard. Next, we're going to talk about the case itself, the facts, the procedural history of Sandler versus Modernizing Medicine, and of course, the ruling, not only at the district court level, but also at the Ninth Circuit level, what the Ninth Circuit did in connection with the district court's ruling. And then lastly, the landscape, how Sandler fits with the broader aspects of not only California law, but federal law in employment arbitrations. And lastly, the takeaways, of course, practical drafting and litigation lessons for California practitioners. What you need to know, because of course we could all read the case, we could all, we're all reasonably smart people and very well educated, no doubt. But what I want to be able to provide for you, the value I'm here for today is the takeaways. Why does it matter? What does Sandler have to do with anything as far as our practices go? And even though I typically represent employers, I've done it both an employer side, for the defense, and also for a plaintiff side, what they would want to know and take away from this case. And of course, lastly, any questions you have for me, any discussion you'd like to bring up, either about this case or employment arbitrations in California in general, I am your source. So the general overview, why does Sandler matter? It's the Ninth Circuit rule for federal courts. So that's really important here. Most of our cases in California are state cases, and California has a tendency to be very strict when it comes to enforcing arbitration agreements. But this being a Ninth Circuit case makes the FAA, the Federal Arbitration Act, front and center. It establishes binding Ninth Circuit authority where that a generic severability clause does not defeat an otherwise clear delegation. And that and this is what's important, California state courts are not necessarily bound by it. Of course, we all took civil procedure back in the first year of law school, and we know that federal law and state law can coexist, but federal law is at best persuasive authority for our state courts. Nonetheless, it's still persuasive, and Sandler matters even at a state level. It also reinforces federal law control. Very often you will see courts say that this is preempted by the FAA, right? Many state law rules, statutes are preempted by the FAA, and that's what Sandler first tackles. Was because, and I'll get to this in a little bit, the facts of Sandler involve both state claims and federal claims. But the arbitration agreement, and we'll look at it very shortly, it said that the employment arbitration agreement was governed by the FAA. So federal law is what controls here. And that's why it's important too, because, and this is a common practice amongst employers in California as well, they will say that the arbitration itself and the arbitration agreement is governed by the FAA. And we might include, say, the California Arbitration Act as the procedural vehicle, to run the arbitration itself, but we do try to get it in under the FAA. So this is going to have broad appeal for California employers. Lastly, it's a useful tool for practitioners, and that's something I alluded to in the last slide, where at the end of this conversation, you as an employer, as counsel for either the employer or the employee are going to know why this case matters for you. So the legal framework, where do we start? We start, of course, with the Federal Arbitration Act. Most of us know it probably cold by now, but that is, it was enacted in 1925. It embodies strong federal policy favoring arbitration of disputes when parties have agreed to it. Courts may not, and this is specific, I mean, it's across the country, but California in particular, California courts may not impose arbitration-specific rules that disfavor arbitration agreements. And you see this all the time with these types of cases. I mean, I keep up, as I was introduced, I keep up with all of these arbitration cases. Last year, there were about 36 published decisions on employment arbitrations alone. The law is ever changing, but the bedrock of that is the FAA, which says, California, you cannot embody a policy or have a policy that disfavors arbitration. The FAA is the backstop. And of course, we have authorities which really espouse everything I just said. Of course, First Options versus Kaplan, Rent-A-Center versus Jackson, AT&T Mobility versus Concepcion, and Kindred Nursing versus Clark. AT&T, of course, basically said that that the FAA preempts any state law that says that disfavors arbitrability, rather. And then First Options and Kindred Nursing then say they take it one step further. And what they say is that if any state law were to try to disfavor arbitration agreements, they are preempted by the FAA. And then we move on to more recent Ninth Circuit rulings, both Brennan versus Opus Bank and Patrick versus Running Warehouse. The reason why I cite these two cases for this seminar is because both of those also incorporated rules into the arbitration agreement for delegation, which is really one of the big factors and parts of import of this case. In Patrick, they incorporated JAMS rules in the arbitration agreement. In Brennan, they incorporated AAA rules. And both said that incorporation was evidence, clear and unmistakable evidence of an intent to abide by those rules. And Sandler takes that one step further. So as I mentioned, we are talking about delegation clauses. What is it? What is a delegation clause? It's a provision in which the parties agree that the arbitrator, and not a court, will decide threshold questions of arbitrability, including whether the arbitration agreement is valid, whether it is enforceable, whether a particular dispute falls within its scope. And why is that important? Because the default rule is that the courts, and this is actually a Supreme Court case, the courts are the ones to decide whether a contract is valid, is enforceable. However, parties can contract around it. And so what most employers now do is say, well, gee, I don't want the court to decide whether my agreement is enforceable, because then it can just go right into deciding issues of unconscionability, which is the next step. Rather, employers would rather have the arbitrator decide. And that way it's already in the venue that they want it to be. So there is a vested interest for employers to have a robust and valid delegation clause. Now, so the second type of clause, and as I mentioned, what we're also going to be talking about are severability clauses. And what is a severability clause? It is designed to preserve an agreement when a single provision or some provisions are found to be invalid or unenforceable. And the idea is that rather than voiding the contract, the offending provision is excised or struck out, and the remainder of the agreement remains in force. So, what's the tension here? I mean, how does one affect the other? That's what was put before Sandler, or the Ninth Circuit in Sandler, I should say. What is the tension? So California decisions, and that's important, state-specific decisions, have suggested that a severability clause referring to a court could create ambiguity about who decides validity and potentially defeating an otherwise clear delegation. So how do we put all that together? That is to say, on the one hand, you have a delegation clause that says a court or other body of jurisdiction has the power to decide whether the scope of the agreement is enforceable. Now you have a second clause that says if a court or other body of competent jurisdiction finds any provision of this agreement to be invalid or unenforceable, such provision will be enforced to the maximum extent permissible, and the remainder of this agreement will continue in full force and effect. So you have these two provisions, which kind of seem a little at odds. At least that's what the plaintiff argued in Sandler, saying that the court is the one to decide whether any of these provisions is invalid, unenforceable, unconscionable. So at least the plaintiff in Sandler argued that that included this delegation clause. Now, before we really dive into what the case said and who argued what further, we have to be reminded of what is controlling here. Federal law is what controls. So we have the clear and unmistakable standard. What is it? Courts presume that questions of arbitrability are for the court. I mentioned that a moment ago. That's the default rule. The presumption, however, can only be overcome when the parties' agreement provides quote unquote clear and unmistakable evidence that they intended to delegate those questions to the arbitrator. So as I said, you can contract around it. However, it has to, as I said, that the standard for deciding whether that's been done, it has to be clear, it has to be unmistakable. So how is the standard satisfied? Well, you can be specific in your agreement. You can have language in there that expressly assigns arbitrability questions to the arbitrator. But that's not what they did in Sandler. They did something a little different. They incorporated institutional rules. They incorporated the rules, in this case, of JAMS, but you can incorporate AAA as well, or any other service provider you might be using, whose rules give arbitrability questions to the arbitrator. And that's why it's very important to select a venue that you're familiar with their rules, because not every arbitrator or arbitral forum has rules that delegate these types of decisions. So you have to look, and if it's not there, and if it's your intention to delegate, you're going to have to write it into your own agreement. But what did the agreement in Sandler say? So the agreement in Sandler had 4 important points. The first being that all disputes shall be subject to binding arbitration under the Federal Arbitration Act in conformity with the procedures of the California Arbitration Act. And that's something I mentioned a few minutes ago, which is you can have both the Federal Arbitration Act working hand in hand with the California Arbitration Act. You use the Federal Arbitration Act to get your case into arbitration because it's much broader. It is much more expansive. It allows for more to come in under it. And then you use the California Arbitration Act to be your procedural vehicle. Have your arbitration governed by the California Arbitration Act. But the FAA designation is what makes this a federal law case, right? And on top of that, Ms. Sandler brought claims both under state court and under federal court jurisdiction. And specifically, she actually alleged age discrimination and sex discrimination, or actually, disability discrimination. But what's important here is that both were working hand in hand, because the California Arbitration Act can't displace and can't preempt the Federal Arbitration Act. And so the express statement that the Federal Arbitration Act is in that agreement made this so important. The second thing that was in the employment arbitration agreement was JAMS administration. The agreement specified that any arbitration would be administered by JAMS pursuant to the JAMS employment arbitration rules. And remember, it's important to go back and look at what they actually say, because they have value beyond just the 4 corners of your arbitration hearing itself. And we'll talk more specifically about which rule brought in the delegation issue. Specifically, it was JAMS Rule 11, jurisdictional and arbitrability of disputes, including disputes over the formation, existence, validity, interpretation, or scope of the agreement under which arbitration is sought, shall be submitted to and ruled on by the arbitrator. So remember our last slide. You can have rules incorporate that you're delegating the issue of validity, scope, enforceability to the arbitrator. Okay, and that's what JAMS Rule 11 does. And courts are not going to want to displace that, typically, at least. And the Sandler court didn't want to either. And lastly, what's relevant for us today is the severability clause. The contract referred to a court or other body of competent jurisdiction making the decision as to whether unconscionable provisions of the agreement should be severed. And so what happened here? What happened in Sandler? Well, at the district court level, I'll start from the beginning, the filing. So Sandler sued in Southern District of California, bringing age and disability discrimination claims under California and federal employment law. I mentioned that already. Modernizing Medicine, ModMed, moved to compel, as one does when they have an employment arbitration agreement with an employee. And they moved under the FAA, they invoked the arbitration agreement, and brought before the court saying, hey, we have these JAMS rules incorporated in it. We specifically said we are incorporating these rules into our agreement. And the idea at the time was to bolster the validity of the agreement. The district court said something interesting. They said, no, we are going to deny the motion to compel arbitration. The claims are going to stay in federal court because they said the severability clause defeated the delegation. Now, how does that work? Well, we'll talk about that in a second. The Ninth Circuit reversed. They said in a unanimous opinion, no, the severability clause and the delegation clause can be harmonized and should be harmonized. One should not compete with the other to be enforced. And we'll talk about actually the exact language, but it was the idea of the severability clause swallowing up the delegation clause. So the two clauses at issue, let's take a look at them. First, the delegation clause, as I mentioned, incorporated by JAMS rules. The arbitration shall be administered by JAMS pursuant to its rules, which provide that the arbitrator must resolve questions of whether the agreement to arbitrate is valid and enforceable. Okay, so that's our delegation clause, and that's very common. That's a typical one, whether it's through incorporation of JAMS or just being expressly written into the agreement. One way or another, very commonly, employers are saying we want the arbitrator to be the one to decide whether the arbitration agreement is valid and enforceable. On the other hand, we have the severability clause, also pretty generic for most employment arbitration agreements. If a court or other body of competent jurisdiction finds any provision of this agreement to be invalid or unenforceable, such provision will be enforced to the maximum extent permissible. Okay, so what's the tension? District court acknowledged that the JAMS rules were incorporated. Okay, and they acknowledged that the JAMS rules specifically said that arbitrability is delegated to the arbitrator. But the court said that the severability clause's reference to a court created ambiguity about who would decide enforceability. Remember, the severability clause said either a court or a body of competent jurisdiction. But what's interesting is the district court only focused on the idea of the court being the one to decide, kind of ignored the fact that there was this other clause that said, or other body of competent jurisdiction. It just said, oh, because you included the idea of a court, now we have ambiguity. And as we know in general contract drafting, ambiguity is very commonly and almost always held against the drafter, in this case, the employer. On top of that, this federal court, district court, relied on California state authority. The court found that ambiguity defeated the delegation. There is a line of about 4 or 5 cases dating back about 15 years that goes to this issue, but they are state cases. And that's what's important here. And that's why we have this kind of tension both between the state courts and the federal courts, and why one is persuasive in context of the other, but not binding, right? So relying on the state court's authority, the district court said, well, because you have referenced a court could decide, that is sufficient ambiguity to defeat the implied delegation, the implicit delegation of your JAMS rules, which there expressly said that the delegation went to the arbitrator. So, having decided the threshold question of whether the court could decide having the court found that delegation did not go to the arbitrator, it stayed with the court, it took the next step. The next step was to decide whether the agreement itself was unconscionable. And in this case, it found it was. Now, of course, ModMed appealed, went up to the Ninth Circuit, and the Ninth Circuit reversed in a unanimous decision. It said that the motion to compel should have been granted. Because the threshold question was that delegation should have gone to the arbitrator. In other words, the arbitrator should have been the one to decide whether the agreement itself was enforceable or not. Then the court could not have come to the next step, made the subsequent determination that the agreement itself was unconscionable. So it vacated the unconscionability judgment because the district court should never have reached the question at all. It was a question reserved for the arbitrator. So the court held a few important things. First, there was clear delegation, that the incorporation of JAM's rules satisfies the clear and unmistakable standard. Second, it determined that there was no conflict between a generic severability clause and the delegation clause, even though it was really a matter of incorporation by reference. The two could be harmonized. I'll talk more about that in a second. And lastly, it reinforced the idea, and I've mentioned this a few times now, kind of in passing, that federal law controls, right? Even though there might be contrary California state law authority, that authority is preempted by the FAA, which is actually one of the most significant parts of this opinion. Because remember, as I mentioned, most California employment arbitration agreements incorporate the FAA. They rely on it. And what the court in Sandler said is that the state law authority is preempted by the FAA. So even if we're not going to be in, say, federal court, even though it might be a state decision or a state law matter, as long as the FAA is invoked, those about 5 or so cases over the last 15 years that held contrary to Sandler cannot be invoked. In other words, Sandler can be relied on when you're invoking the FAA to say, hey, there is no disharmony between delegation clauses and severability clauses. So this is the court's reasoning, and this is kind of what we've been building up to this point. So if we adopt, the court said if we adopt the plaintiff's interpretation, that would, as I mentioned, allow the severability clause to quote unquote swallow up the delegation clause. It would render the delegation clause superfluous. It would have no purpose. It would have no meaning if the severability clause, if the courts could excise the delegation clause, then it would just never have a purpose to begin with. So what the Ninth Circuit decided was that two things can be true at once. First, that parties can agree that disputes, including disputes over the validity of the arbitration agreement itself, will be heard by an arbitrator. All right, kind of figured that out by now. Second, the parties can also agree on a contingency. So it's kind of a step A or step one and step two, right? So if you have delegation, then we're going to honor the delegation. But if for some reason the remainder of the agreement is unenforceable, if other provisions are unenforceable, or if the delegation clause itself is a problem, then the court can reach questions of enforceability. But a severability clause limits the consequences. So that's actually really important. So it's a step one, step two process, right? First, we take a look. Is there a valid delegation clause? If yes, you go straight to the arbitrator. You're not pass go, or you are going to pass go and collect $200 that time, right? However, if there's a problem with the delegation clause, then the severability provision might come into play. And that is when a court can weigh in. Hey, is the delegation clause itself enforceable or valid? Because that would therefore be an even further back threshold question. It doesn't necessarily automatically go to the arbitrator if there's a problem with the clause itself. So that was the court's reasoning. As I mentioned, the FAA preemption was a very big component of this decision. The clear and unmistakable standard is an arbitration-specific rule. To have a state law rather than federal law control the content of that rule in a way that disfavors arbitration would subject it to the FAA preemption. That's what the court said. So the way, to kind of unwind all of that jargon is by saying, if you are going to invoke the FAA as part of your agreement, even if you are a California employer, you have as long as you have some bearing on interstate commerce, and just about everybody does somehow, then even if no federal claims are being alleged, as long as you're within the FAA, all of those state cases that say that say delegation can be swallowed up by severability clauses, such as the ones over the last 15 years in state courts, those are preempted. You cannot rely on those anymore as long as the FAA is in play. So another multi-step process. The federal question, whether parties delegated arbitrability is a question of federal law. But again, that's assuming that the FAA is explicit in the agreement. Then we move on to what the state rules say. If the state rules disfavor, then they will not be applied. California interpretations that treat severability as defeating delegation disfavored arbitration. And so those cannot be applied in, say, opposition to a motion to compel arbitration, because those interpretations are preempted by Sandler and federal law. So lastly, as I said, preempted. So such state rules are preempted under Concepcion and kindred nursing. So very, very quick and easy three-step process. Number one, does the FAA apply? Are you saying it does? If so, you cannot apply the California cases that disfavor arbitration. Why? Number three, because they are preempted under federal law. Now, the broader California landscape in context. So, as I mentioned, there were a number of California cases that are preempted. Jack versus Ring is one. Najaro versus Superior Court is another. Dennison versus Roslyn Cap, Hartley versus Superior Court, Pareda versus Superior Court, and Baker versus Osborne Development. All of these essentially said that delegation clauses can be excised and kind of ignored under federal under if you have a severability clause, right? And as I said, these cases now are no longer enforced, can no longer be applied in an opposition. Okay. Ninth Circuit has a parallel trend. So Odell versus Aya versus Healthcare Services decided just 2 weeks later, 2 weeks after Sandler, rather, reverse a Southern District California order denying a motion to compel arbitration based on non-mutual offensive collateral estoppel, holding that approach with the FAA. So the idea and the reason why we talk about that is you see now on a federal level, and I would say this is true over the last year or so, you see a much stronger push at a federal level to enforce arbitration agreements just about any way they can be. And what Odell did, even though it had something to do with a different subject matter in these arbitration proceedings, is that there is now a greater push at the federal level to have arbitration agreements enforced. And so now we are seeing much more of a pro-enforcement posture. Next, the counterweight. So Hohenschelt versus Superior Court. This was an interesting case. This was actually a bellwether case that came out in last year that decided that arbitration fee timing is not as bright line rule as we once thought. Prior to Hohenschelt, what the courts in California said was, if you miss the payment deadline by even 1 day, for any reason, it doesn't matter if there was no fault, it doesn't matter if there was a postal error, it doesn't matter if you got flooded out of your home and couldn't get access to a computer or anything, or whatever the case may be. What the court said in Hohenschelt was, no, we are not going to penalize people, or rather employers, for missing a payment that is made in good faith, essentially. So what are good faith? What was the idea behind that? Well, the court acknowledged that sometimes life happens. Sometimes it's not the employer's fault that the payment wasn't made exactly within the 30-day safe harbor period. And so there, Hohenschelt on the one hand dealt with advancing the idea of keeping, being pro-arbitration, having arbitration agreements enforced when they were intended to be enforced. But there was another aspect of what Hohenschelt did, and this is what the subject of the slide is that Hohenschelt said, we are not going to actually go so far as to preempt the statute, the fee timing of the fee payment statute. That's section 1281.98 of the California Code of Civil Procedure. The FAA doesn't preempt it, but the second step of that was that even though it's not preempted, courts cannot use it to abuse a system that is designed and intended to have employers have their cases in arbitration, which was what they originally contracted to do. And to take it one step further, again, what Hohenschelt intended and is a really big win for employers last year was that now we have these good faith defenses. If there was a legitimate reason, it was not gamesmanship or ignoring or missing the timing of the fee payment, then it's okay. You are not out of luck necessarily. Although you still do actually have to make a showing before the court as to why the timing of the fee payment was missed. Now, what Sandler doesn't decide, Sandler doesn't do certain things. It's very specific and very clear as to what it did, but what it doesn't do is challenge, and I mentioned this, it doesn't change that employees and plaintiffs' attorneys can challenge the delegation clauses themselves. And that was under Rent-A-Center. You can have a challenge targeted at the delegation clause as opposed to, the broader arbitration agreement, right? And that's still okay. You can still challenge the delegation clause as if it's for some reason unconscionable. Let's suppose you don't write in that you incorporated the arbitration rules of JAMS or AAA. Let's suppose somehow you had you expressly designated authority to the arbitrator, but you did so in such a way as to be unconscionable. So that's kind of what happened in Rent-A-Center, and that's still permissible. So, and that goes to the idea that severability clauses and delegation clauses can work in harmony. Severability clause, Sandler didn't say that severability can't completely ignore delegation clauses. It can still excise unconscionable provisions, and those unconscionable provisions can be in the delegation clause itself, but the severability, what it can't do, the severability clause cannot do is just do entirely away with the delegation clause without closer analysis. The next thing is that unconscionability isn't eliminated. Now, remember back in the Sandler slides, the district court engaged in a two-step process. The idea that, okay, we've found that the delegation clause is unconscionable. So we're going to take the second step and determine whether the rest of the agreement is unconscionable as well. Well, the Ninth Circuit said, hold on, no, you did not meet the threshold of finding that the court had authority to hear the unconscionability question. It was reserved for the arbitrator. So the idea is we're only talking about step one with Sandler. Who has the authority? Who has the delegation authority to determine whether enforceability, validity of the arbitration agreement exists? Whether it comes from the arbitrator, whether the arbitrator decides that it is enforceable or valid or not, or the court, is only the first step. After the decision is made, then either the arbitrator or the court is going to decide the second question, unconscionability. Is the agreement itself unconscionable? So as I mentioned, the unconscionability fight isn't gone. It just moves to the arbitrator or the court, as the case may be, but the first decision needs to be made first. So what Sandler does is it shifts the forum, assuming that the delegation clause is valid. Next, the EFAA carve-out is unaffected. So what's the EFAA? That's the Ending Forced Arbitration Act, and Ending Forced Arbitration of Sexual Harassment, Sexual Assault Act. And so what that is that claims that have to do with sexual harassment or sexual assault are carved out under federal law, and that's unaffected. Those claims will always defeat a motion to compel arbitration, because what the courts have said over the last few years is that any claim, even if it's brought with claims of, say, wage and hour claims, other disability discrimination claims, other harassment claims, as long as there is a claim for sexual assault or sexual harassment, along with everybody else, at the election of the employee, those claims cannot be compelled to arbitration. Rather, not even just the claims, the entire case. So it's not that the courts can somehow split the sexual assault or sexual harassment claims, keep them in court, and everything else goes to arbitration. No, excuse me, no. Everything would stay in Superior Court, and Sandler does not change that determination. And then beyond jams in the employment context. So, as I mentioned quite early on in this presentation, different arbitration forums have different rules. You need to look at them. Not every forum incorporates a delegation clause. So if you as the employer are drafting an arbitration agreement and you say, well, I want to use signature. But, and I don't know if this is true, but let's say signature doesn't have a delegation clause. Then you're open to the court deciding the delegation issue. You're open to the court, actually not even the delegation issue, you're open to the court deciding whether your agreement is valid and enforceable, because you have not made any determination as to who is going to decide. And once again, the default rule is that the courts decide unless the parties contract differently. Okay, so as a drafting point, and we'll talk more about this in actually the next slide, as a drafting point, always be careful of what the provider rules you are using, what they say. Okay, so we know, for example, JAMS does, that's Rule 11. We know AAA does. They also have a similar delegation clause. And so you can simply write in, and what Sandler now allows us as representatives of the employers to do is allow us to write in and say, we are incorporating JAMS rules entirely, and leave it at that. And that's okay now. So now let's talk about the drafting tips. What can we as practitioners on both sides of the aisle do? So the drafting takeaways, and I'll start with the obvious. Incorporating JAMS, AAA, or comparable rules alone is sufficient under Sandler. We just talked about that. So if you have, let's say you represent employers, your existing agreements that you do the drafting for those employers, they might not need any revision. As long as they expressly state we are incorporating JAMS or AAA rules or other comparable rules, assuming they're valid, that's okay. You don't have to do anything anymore. But you might take a belt and suspenders approach. You might do both. You might incorporate the provider rules expressly, but then you can also add an express standalone delegation clause. It's not required under Sandler, but it provides a second independent basis for arbitral resolution. So it just takes away a potential argument if you're the employer from an employee saying, no, we want the court to decide. Another drafting rule, takeaway rather, is to keep the severability generic and symmetric. You can, and this is what they actually did in Sandler, and that's what it's important. You want to be able to reference both a court and other body of competent jurisdiction. The Sandler court expressly approved that. And the Sandler court said that this is not ambiguous. You can have one or the other as a contingency. Okay. Lastly, you're going to choose your governing law carefully. And this is something I have been very, very animate about throughout this presentation, which is that be sure, if it's appropriate and applicable, to state that the FAA governs your agreement. Because if the FAA does not govern, then Sandler does nothing for you. If you are only going to say that the California Arbitration Act is what governs both governs your ability to get in to arbitration and governs the arbitration hearing itself, then Sandler doesn't help you. You are stuck with state law rules because nothing's going to preempt them. So those 5 cases I mentioned a few minutes ago are going to apply. They are not preempted anymore because you have not invoked the FAA. So this is the slide I was really wanting to get to today for both sides of the V. So we're going to do employers and we're going to do plaintiffs' attorneys and employees. So for the defense, what should you do? Lead with a delegation argument. So the idea is, let's say you are filing your motion to compel. You are going to say the court has no jurisdiction to decide whether the agreement's enforceable. You are going to say, here's my delegation clause. So you're going to lead with that. You're going to have the arbitrator, you're going to tell the court, you have no jurisdiction. The arbitrator is going to be the one to decide the validity. You're going to cite Sandler and argue against any severability-based ambiguity arguments, much as the ModMed did in Sandler itself. You're going to frame arbitrability as a federal law question. You're going to press FAA preemption. It's actually a very valuable tool, and it's becoming more prevalent with each passing month. With each new decision, the FAA preemption is a very common and very topical argument to make. But that, once again, assumes that you are expressly writing in that the employer, rather that the arbitration agreement is subject to the FAA. And a word on that. You know, I once had, as a very young attorney, although I hopefully still look young, but as a very young attorney, I once had a judge in San Bernardino compliment me in my motion to compel arbitration for explaining why the employer was invoking the FAA and why it was subject to the FAA. And frankly, it was as simple as writing in the arbitration agreement and being able to rely on it in the motion to compel that the FAA applied because the employer was involved in interstate commerce. Done. Simple. Because if you just leave it and say the FAA applies, well, then you have to make the additional showing of why it applies. But if in the arbitration agreement itself, you write in that it applies because the employer is engaged in interstate commerce, well, boom, you're done. You've already taken a very quick and easy step into proving why the FAA applies, and from there preempts various state law rules that might disfavor arbitration. Next, you're in your motion to compel, you're going to want to anticipate any unconscionability defenses being raised, but nonetheless, I mean, and this is why you're going to lead with it. You're going to argue that the court has no jurisdiction to determine unconscionability at the stage. It's delegated to the arbitrator and not the court. Now, if you're the plaintiffs, what is your takeaway from Sandler? If you're a plaintiff's attorney, if you represent employees, what is your takeaway? So there are severability-based ambiguity arguments, but they are now weaker under Sandler. They're not gone. Remember, you're going to look very carefully to see if the FAA applies to the arbitration agreement you're opposing. If it doesn't, well, you have a plethora, about 5 or so state court cases that favor you. And Sandler does not help the employer because the FAA is not at issue here, and it can't preempt those cases. You're going to focus on whether incorporation of provider rules is truly clear and unmistakable. Now, I haven't reviewed all of, every provider's rules. I know JAMS, I know AAA's, but there might be signature, there might be another arbitration provider where it's ambiguous. You're going to have to go through and actually look at what the rules state if they are incorporated. And you could theoretically, depending on how they're worded, make an argument that the delegation to the arbitrator is not clear and unmistakable. You're also going to look for challenges specific to the delegation clause itself, not the arbitration agreement as a whole. So what do I mean by that? And this is kind of something I alluded to previously. You can still challenge the delegation clause. And if the delegation clause is found to be unconscionable, then the severance clause will come in, strike it out, and boom, you're still in court because the delegation clause itself was invalid or unenforceable. So you can still make the challenge, it just has to be targeted. Lastly, you're going to preserve unconscionability challenges for the arbitrator where required. So let's suppose you are not successful in challenging the delegation clause. Well, you're going to preserve the right, and you're going to raise the unconscionability issue before the arbitrator. It never goes away. You're still going to make the argument. It's either going to be in front of the court, which I know many plaintiffs' attorneys prefer, or it'll be in front of the arbitrator. But one way or another, the question of unconscionability of the agreement itself does not go away. It's just the second step in the process. So I've left a few minutes for any questions that anybody might have or any discussion topics I'm happy to talk about. This case, broader trends in arbitrations and employment cases in California. But I open the floor to everyone. Okay, well, I just want to take this opportunity while we still have a few minutes left. I wanted to take this opportunity and say arbitration agreements and employment arbitration cases are ever developing, okay? And as I mentioned, last year alone, there were 36 new published decisions, both on a state and federal level, okay? And so it's imperative that employers and employees alike keep up with the developments. These developments are so critical because they change literally from month to month. As I was introduced, it was mentioned that I've written over 100 articles on this subject. That's absolutely true because there are just so many cases each and every month that come out that change the employment arbitration landscape. And if you are not constantly updating your arbitration agreement, if you are not constantly keeping up with these case developments, you could be left behind. Something that might have worked a year or two ago might not work now. And so if you have counsel, please keep up with them, check in every 6 months or so and say, hey, is there any new case I should know about? Do I need to update my arbitration agreement? And very commonly, the answer is yes. You should be updating it at least once a year because of how frequently these arbitration cases come down and change the landscape, not only for employers, but for employees. And as long as you're keeping up with it, you should be okay. But if you are not keeping up with it, you risk staying in court for one reason or another. And I assume if you prepared and provided an arbitration agreement to your employees, you intended to be an arbitration. Despite how much it might cost, you made a cost-benefit analysis. But even so, the takeaway, broader than just Sandler, is to stay up to date. And that's my one plea to everybody watching is keep up with current developments. Feel free, minor plug, but feel free to stay up to date on my profile. You could look me up online, and I write about every development as it comes down. So, there are many resources out there. And, if you check once a month, just briefly, hey, are there any arbitration cases even every 6 months? You should be in good stead. But with that, I want to thank everyone for attending today. I really appreciate your time and interest in this subject. If there's any questions after the seminar, you can reach me at jslater@ecjlaw.com or give me a call at my number on the screen. As I mentioned, I do typically represent employers, but I am always happy and interested in discussing these developments with anybody who would like to reach out. So with that, I would like to all thank you once again. I'd like to thank the Beverly Hills Bar Association for giving me the opportunity to speak today. And I wish you all a wonderful day.
This concludes today's presentation. Thank you so much, Jared, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everyone.
Thank you.